Good morning, everybody. Welcome to this session of the 4th District Court of Appeal. Just a few preliminary comments about operating on Zoom. If you're not speaking, we found that it's a good idea to put yourself on mute. Now, when I forget to unmute myself, if you point to your ear like this, then I'll pick up that cue and we'll do the same thing for you in case you similarly have the problem that I do on these Zoom calls. We haven't had any technical problems to speak of, but if for some reason one of the judges were to drop off, continue your argument because these sessions are being recorded and the judge will be able to view the argument that you're making later. Now, if we have problems on your end, we'll stop and our excellent technical folks will sort of get us back up and running. So not to worry if that issue happens. We've been pretty good over the course of this virtual year in handling all the problems that have arisen thanks to Brandon and Laura and Lon and the other folks that are working to really make this a seamless experience. With that underway, we have the first case is AIELLO versus ASI Preferred Corporation. Is the appellant ready to proceed?
Yes, thank you, Your Honor. May it please the court, I'm Rebecca Vargas from Kreuzler, Walsh, Vargas, and Seraphin. I'm here on behalf of the insured, the AIELLOs. I'd like to reserve 3 minutes for rebuttal. The severability clause in this homeowner's policy creates separate coverage for AJ AIELLO, who did not own this boat. The trial court erred in ignoring the severability clause and denying coverage. This court must reverse the summary judgment. Starting with the language of the policy, there's an exclusion here from this homeowner's policy for personal injuries that were and medical payments arising out of the use of an excluded watercraft. However, there's an exception from this exclusion for boats of 4 different categories of sizes, depending on what type of engine is involved. And but there's a critical distinction is in our situation, we're looking at category D, which is 1 or more outboard engines or motors with more than 25 total horsepower if the outboard engine or motor is not owned by an insured. And in this case, it's very undisputed that AJ AIELLO, who was driving the boat, was not the owner of the boat. He is insured under the policy because he was a resident of the household. The court must read the exclusion of the policy together with the severability clause, because the severability clause here is very important and expressly provides that the insurance applies separately to each insured. That severability clause creates a reasonable expectation on behalf of the insured, AJ AIELLO, that the exclusion of the policy should apply specifically to him. And that conclusion would be reasonable because under this court's longstanding precedent, going back to 1966, 55 years ago, in Shelby Mutual versus Shutema, this court explained what is the impact of a severability clause, and it really creates a separate insurable interest on behalf of each insured, because there are many situations when an insurance policy covers multiple insureds. And when the policy uses the term insured and has a severability clause, the effect of that severability of interest clause is to make certain that the policy should be read as if that policy exclusion only applies to the insured who's seeking coverage under that claim. Now, we are lucky enough here in Florida to have a trio of cases applying similar exclusions in homeowners policies and talking about the impact of when you have a severability clause and you have a exclusion and how should you construe the policy. And the most important case that I'd urge the court to read is Premier versus Adams out of the 5th District, which also involved a son of the insured who was a resident of the household. And the court held that to give reasonable meaning to both the severability clause and the exclusion, for an intentional act by any insured, the court had to construe the policy as ambiguous, and the exclusion only applied to the individual insured seeking coverage. And the court acknowledged that that did render the term any insured in the exclusion superfluous, but it found that preferable to rendering the entire severability clause meaningless, because really that is the purpose of providing several or separate insurance as opposed to collective insurance. So I know that ASI tries to distinguish the language in the Premier versus Adams case as involving, slightly different language in the exclusion, because in that case, it was an exclusion for intentional acts by any insured, and our exclusion is for a boat owned by an insured. But really, that's not a meaningful distinction, because in the very thoughtful analysis in Adams, the court looked at multiple cases from other jurisdictions. It recognized the split in authority, and it cited and analyzed cases from other states using the policy language the insured, and the policy language an insured, and the policy language any insured. And it found the effect is the same, regardless of which phrase is used in the policy exception.
Counsel, doesn't the fact that they did use the language "and insured" isn't the father of the young man who was in charge of the boat or captaining the boat at the time that is also an insured and insured? In other words, isn't the father an insured and he's the owner of the boat?
Yes, Your Honor.
That's not, you don't think that's a distinguishing point on some of the cases? I wanted you to, you sort of addressed that, but it seems to me that the language would include an insured. How is that to the exclusion of, why do you have to exclude all insureds from the policy language in order to come to the conclusion that you are?
Well, Your Honor, in this case, only the father, who is one of the insureds, owned the boat. The son, AJ, is a resident relative. He did not own the boat. And the cases, the Premier case, followed by the Halen case, followed by the Taylor case, they all looked at this language and said it is ambiguous once you read it with the severability clause, which creates separate coverage for each insured, and the insuring clause creating separate coverage for each insured. And the Halen case out of the 5th District actually used the language "and insured." So although Premier used any insured, Halen used "and insured." And it found that under the rationale of Adams, the exclusion had to be read separately as applying to each specific insured who's seeking coverage. And that's consistent with the longstanding canons of insurance policy construction, that any ambiguities in the policy must be read in favor of coverage. And that's especially true when there's an exclusion to coverage.
So your position would be that if any person in the family household that's covered by the policy does not own the boat, then they would be covered, whereas the person who does own the boat is not covered if they happen to be captaining the boat at the time of the accident.
Correct. In this policy, it has to be read as to each individual insured. So if the insured is not the owner of the boat, then they remain covered. And what is critical here is the language of the exception to the exclusion is limited to the an insured who owns the boat. And so when you read that together with the severability clause, I think it's a reasonable construction to find that it is limited to the person who's seeking coverage. And the Adams case is quite helpful on this, because it reasoned that even though this gives less meaning to the term any insured, and perhaps even renders it superfluous, that's preferable to an interpretation that would render the entire severability clause meaningless.
Is there a manner that it could have been drafted to exclude for any insured in your view? I mean, if any insured doesn't do it or an insured doesn't do it.
Yes, Your Honor, I think that the policy could have used different language to refer to all of the name and to refer to everyone, all of the insureds, and it could refer to them collectively instead of severally. But instead, we've got a severability clause here that says that the policy, this insurance applies separately to each insured. So I think there is a possibility that they could draft this differently, but they haven't done that here. And the standard canons of insurance are that any ambiguities are resolved in favor of coverage and in favor of the insured. I'm sorry, go ahead.
Yeah, if you had so if Mr. AIELLO, the father, was on the boat at the time, together with the son, and they were both sued in their individual capacities. You're saying the insurance policy would cover the son who does not own the boat, but it would not cover the father who owns the boat. That would be your interpretation.
Right. So under your scenario, you mean that the father was driving the boat?
Yeah, let's say he was on the boat and was aware of what was going on, and they came up with a theory as to why both they were going to sue both father and son for their activities on the boat. The father would not be covered, but the son would be covered under your theory. Right.
And we conceded below in the hearing on the summary judgment that the father would not be covered, but we're only seeking coverage for AIELLO here. With that, I'd like to reserve the rest of my time for rebuttal. Thank you.
Your Honors, may it please the court. There are two issues here. The first is whether ASI was properly granted summary judgment based on the watercraft exclusion. And the second is whether the trial court's judgment should alternatively be affirmed under tipsy coachman because the criminal or illegal activity exclusion in the policy applies. I'll start with the watercraft exclusion. It's ASI's position that this exclusion is unambiguous and the severability clause does not change that. Its plain meaning is that there is to be no liability coverage for excluded watercraft. It's a very broad exclusion, and it is meant to preclude coverage for a whole category of items, watercraft. There are just 4 narrow exceptions to the exclusion, and none apply under the plain language. Appellant's argument is that the severability clause creates ambiguity in the watercraft exclusion, particularly the phrase not owned by an insured. It's our position that the watercraft exclusion is clear and unambiguous, and appellant wants to use the severability clause to impermissibly rewrite the policy to give it an unreasonable interpretation and create an absurd result. The initial exclusionary provision precludes liability coverage for bodily injury or property damage arising out of the ownership, maintenance, use, loading or unloading of an excluded watercraft, defined below. It proceeds to define excluded watercraft as those principally designed to be propelled by engine power or electric motor, etc., whether owned or rented to an insured. So both the initial exclusionary provision and the definition of excluded watercraft are extremely broad and meant to create a blanket exclusion for watercrafts, such that any boat an insured owns or rents is an excluded watercraft for which there is no liability coverage. As discussed in our brief, every time the watercraft exclusion refers to an insured, it says just that, an insured, not the insured. And each time the word insured is in quotes because that term is specifically defined. There's no dispute that all of the AIELLOs are insureds under the policy. The plain meaning and ordinary rules of construction strongly support ASI's position that an insured means any insured, and the relevant case law is also extremely strong that an and any are synonymous. Here that means if any of the AIELLOs own the Twin V, then it is an excluded watercraft, and Mr. AIELLO undisputedly owns the Twin V. Instead of properly considering the watercraft exclusion as a whole, appellant hyper-focuses on the last component of the watercraft exclusion, which is a set of 4 extremely narrow exceptions. She recognizes that only exception 1D could potentially apply here, given the boat that we have at issue. And exception 1D begins and ends with the following key phrases. This exclusion does not apply to watercraft, ... not owned by an insured. The focus is on the vessel. And the exception plainly does not apply because the boat and motor at issue are owned by an insured, Mr. AIELLO. Therefore, the Twin V is an excluded watercraft, not coming in under any exception, so there is no coverage. The severability clause does not make that clear language ambiguous. Appellants just want to use the severability clause to rewrite the policy so that every instance of the phrase "and insured" instead reads "the insured who is seeking coverage." From there, they argue that because the boat here at issue is not owned by AJ, he is covered. That's not a reasonable interpretation. The severability clause states in its entirety, this insurance applies separately to each insured. This condition will not increase our limit of liability for any one occurrence. Our position is first that the severability clause doesn't give the plainly worded watercraft exclusion the meaning that appellants advance. The watercraft exclusion excludes watercraft, a whole category of items. The clause, this insurance applies separately to each insured, doesn't change that. Our second position is that accepting appellant's argument would lead to absurd results, not only in this case by rewriting the plainly worded watercraft exclusion in this standard homeowner's policy to make it into a watercraft liability policy, but also more broadly, because the policy here at issue is not the only thing at stake. Every other watercraft exclusion in every homeowner's policy in Florida will be affected by this court's decision. And for that matter, so will every homeowner's policy exclusion for recreational vehicles, like ATVs, as referenced in our brief. Certainly, as judges on the fourth, you can imagine what a widespread and drastic effect that would have on homeowners insurers throughout Florida. But returning just to the terms of this policy for the moment, appellant's interpretation is insupportable. Appellants can't use the severability clause to rewrite the policy to change "and" to "the," because as appellant's own brief recognizes, policies are construed in accordance with the plain language of the policy as bargained for by the parties. The plain language of the watercraft exclusion is that because Mr. AIELLO is an insured and motorboats like the Twin V here at issue are owned by an insured are excluded watercraft, the Twin V is excluded and there's no coverage. The severability clause doesn't render that plain language ambiguous because the case law is clear that ambiguity means the language is susceptible to more than one reasonable interpretation. And appellant's interpretation is simply not reasonable. It's rewriting the policy to change "and" to "the," with the result that it would turn a very broad exclusion into a very broad coverage provision.
Counsel, what is your reasonable interpretation of this insurance applies separately to each insured? What do you believe that, what is the reasonable interpretation of how that operates in this context?
So looking at the case law that appellant relies on heavily, 3 out of 4 of those cases deal with intentional acts exclusions, conduct-based exclusions. The severability clause, as applied to exclusions like that, makes very good sense for treating each insured separately based on their separate conduct. This is an exclusion for a class or category of items. It doesn't really make sense to apply the severability clause the way that she's talking about because it vitiates that entire setup of focusing on the vessel, saying this exclusion applies to watercraft, this exclusion doesn't apply to watercraft owned by an insured, etc. I would direct the court to our case, California Insurance Company versus Northland Insurance Company, which has a very helpful and well-reasoned discussion of the real purpose of severability of interest provisions. Returning to my argument, appellant also goes on about strict construction, and although appellant makes much of that, this court has acknowledged that exclusionary clauses are strictly construed only in the sense that the insurer is required to make clear precisely what is excluded from coverage. The watercraft exclusion does that. It makes clear that certain types of vessels, items, are excluded from coverage. The focus is not on the insured or whose conduct is at issue. Given the time I have left, I'd like to proceed to the tipsy coachman illegal activity exclusion. Even if the court agrees with appellant's position on the watercraft exclusion, judgment for ASI must nevertheless be affirmed because the policy's criminal or illegal activity exclusion applies. That exclusion precludes liability for bodily injury or property damage arising out of criminal or illegal activity, meaning any and all criminal or illegal acts performed by an insured, regardless of whether the consequences of those acts were intended or anticipated.
Counsel, is there is with respect to that exclusion, the arising out of language. I mean, I know that the three folks on the board were all under 21, that there was alcohol in the boat that arguably they jointly possessed or constructively possessed. But doesn't there have to be proof that activity, that criminal activity, caused or led to or contributed to the accident itself? And if so, is there evidence, undisputed evidence, that that is true?
No, Your Honor. Actually, the case law is absolutely clear that arising out of does not mean proximate causation. It does not even mean caused by. It is much broader. Florida's courts have looked at the term arising out of, which is a standard policy terms, many times over the years, and it was decided long ago that it means incident to or having a connection with. The nexus is very, very broad. And the undisputed evidence does clearly establish that nexus. There's not a shred of evidence to the contrary that they all possessed alcohol. They all even drank some alcohol in the day in question. And it's also undisputed that AJ entrusted the boat to Carolyn Fairgrass without knowing whether she was competent to pilot it and knowing she had consumed alcohol, and that she then crashed the boat. So all of the relevant material facts are undisputed. The only thing left is for a court to decide whether the law arising out of applies to those facts, such that the criminal or illegal activity exclusion applies to preclude coverage. That's appropriate for summary judgment, and that's also appropriate for this court on appeal under tipsy coachment. And we would say that under the case law for arising out of, there's no question the criminal or illegal activity exclusion applies. 17 seconds. Do you have any more questions?
Guess not. Thank you very much, counsel. Ms. Vargas, back to you.
Thank you. Turning first to the argument that this court should be persuaded by the California case that counsel cites, there's no reason to turn to California law because we've got law right on point here in Florida. The Premier versus Adams case analyzed the split of authority and has a very well-reasoned decision where it really adopts the weight of authority. So there's no reason to turn to California.
So, Ms. Vargas, do you think, I mean, if we disagreed with you you know, on that issue, you know, how to construe and insured under this particular policy, do you believe that there would be an express and direct conflict with Premier so that you would try to take that conflict up to the Supreme Court?
Yes, Your Honor, I do think that it would be in conflict, not just with Premier, but also from Taylor out of the 3rd District. I think that both of those are right on point as far as the effect of the severability clause. And it's really, even upon looking at this court's prior decision in Chutema back in 1966, I think that gives us very good guidance on how to read the severability clause and what's the impact of a severability clause in this type of a policy.
Do you want to address the thing that I'm concerned with, the alternative ground discussed with your opponent?
Yes, I would. Thanks. The tipsy coachman does not supply an alternate base for affirmance here because this is not a matter that could be decided on summary judgment. As Judge Gross pointed out, there does have to be a causal connection. The only criminal act that's alleged here is the possession of alcohol. There's no allegation of driving under the influence, voting under the influence. And there was evidence that there was no evidence that anyone on the boat was impaired, or slurring their speech, or under the influence. And so it would be really a fact question, a disputed fact for the jury, whether the small amount of alcohol on the boat and the fact that they were minors had any relationship to the accident. Accident was caused by an unlit channel marker when with 4 people driving on the boat at night, and the boat was a small boat that tended to move quick, to shift when people moved around the boat. So it would be a factual dispute as to what was the cause of this accident. With that, I'd ask the court to affirm, and thank you for your time and listening to our argument today. Or excuse me, to reverse the summary judgment.
We would have figured that out, So. Listen,
Thank
thank you very much, folks. That was well argued by both sides. So thank you for your participation.